this is Chris from the Ticket Stub. You're listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Hi, welcome to the Legal Connection Show. This is Tony Collins, and our show airs every Tuesday from noon to 1, and we're helping the general public with some legal issues. You can find us on FM 104.5 and FM 106.1, and also on Facebook at The Legal Connection Show, as well as on YouTube if you Google The Legal Connection Show. Today's show is going to be on traffic tickets. And I am here with my co-host, Cheryl Christine Ellsworth De Lavani Giovanni. Ronnie?
That's close enough, Tony.
Okay. All right, so tell us about what segments we have. What are we going to cover today?
We're going to cover, do you have to pay the traffic ticket?
Mm-hmm.
We're going to cover if you are stopped for traveling over the posted speed limit, are you guilty of speeding?
Mm-hmm.
And we're going to talk about what if the police fabricate or charge you with speeding just to stop you to try to find another reason to arrest you.
So, yes, these are issues that have come up with my clients, and I'm sure yours too, over the holiday season. And so before we get into each one of our segments, you were telling me that just personally that you've had some traffic tickets. I have too, and so you said your nephew had one, or what's going on with that?
Yeah, he has. Well, actually, it's not my nephew; it's a client.
Uh-huh.
But they got a speeding ticket for going. I think it was 80 and a 55.
Okay, and let me ask you another question about that. I'm going to be like I guess, voice of reason here. So he was going 80 to 55. Was that in Montgomery County?
Yes, it was.
Okay. And was it in a residential area or on a highway?
Tony, I think it was a highway.
Okay. And the reason I ask is we're trying to show our listeners sort of how you analyze how you address a speeding ticket. And, we've done other shows on the anatomy of a ticket and basically when you get stopped, what happens when you get to court and how you can dispose of it. But we're not going to go into the nitty gritty of what happens when you get to court, when you get the ticket. Instead, we're going to look at some other issues. And one of them that we're covering in our second segment today is whether or not you're actually speeding if you go over the posted speed. But first, let's say your client was actually going 80 miles an hour in a 55, and that wasn't, reasonable, and he admits guilt, okay? Or let's say that your client got a ticket in maybe a different county. He was, speeding through Austin to get to Eastland, Texas, or something, or trying to get to San Antonio before the snowstorm hit, or whatever. Let's just say that it was in a different county, and he did not receive a copy of the ticket in the mail, or he got it and it got mixed in with some Christmas stuff, or maybe he's not at the residence that's on his driver's license because of COVID or whatever, but he missed the date to respond to it, and he got a failure to appear warrant issued. A speeding ticket is not an arrestable offense unless, of course, it was reckless driving. It goes above the level of speeding. But if you don't show up for court for a non-arrestable offense, or if you don't give the police officer that stops you if you don't sign the ticket that he's giving you, then they can arrest you, or there'll be a warrant for your arrest. And I'll just add not necessarily the caveat, but that in the past, I've had clients who have argued with police officers, which is a cardinal rule. You don't argue with the police officer when they stop you. Right. You're very polite. You show that you are concerned with their safety. You pull off far enough away that they have safety. the kinder you are to this police officer who may or may not have had, reasonable suspicion or probable cause to pull you over, the nicer you are, the more likely it is that either you'll only get a warning or things will go more smoothly. And so if the officer asks you to sign off on the ticket, acknowledging when you will show up, which they've got those little things that print out by the car now, you actually get a little printed receipt, then you need to sign that, because if you don't sign it, they can actually arrest you, so that you can be brought before a magistrate, so that they will tell you by a judge's order when you have to appear. And it's kind of snarly that they would even stoop to that, but my client was arrested for not signing a ticket. And
oh my goodness.
I did not know that you could be arrested for not signing a ticket, because you're not admitting guilt. You're just saying you're going to be. But the whole statute and premise behind it is you're acknowledging that you know when to reappear for this non-arrestable offense. And so just sign it.
Yeah.
I mean, you don't want to sign, you want to ask, and you might have your phone in record mode, like I always ask my clients to do. But if you put your phone in record mode and the officer thinks you're reaching for a gun, you might be in trouble. So at all times, you want the officer to see your hands, and you want to make sure you tell them, by the way, I'm reaching over to put my phone down, and you just tap it on record. But don't be making, crazy movements and all that stuff, because in this day and age, you're just, particularly in a conservative state, you're just asking for things to snowball out of control. So now, if you are guilty because either you didn't show up during the time frame that you were given to show up, or you didn't take care of the ticket before the time frame when you were supposed to show up, or you just pled guilty, then there is still, to answer the first question, you may still not need to pay for that traffic ticket. And I wanted to go back just a little bit. I think most people have gotten a traffic ticket before. And they usually give you an option in Montgomery County with the JP courts that you can, and it actually says it on the ticket, and it says it on their website, that you can dispose of this ticket by agreeing to do a deferred adjudication, by taking a driver's ed course online, or whatever the terms are that they are offering through that court. You can usually do that ahead of time, and that disposes of the case, and you don't have to show up. But let's say you don't want to do that and you want to fight it, and then you miss your date. Or let's say you just don't do anything and you miss your date. And you've now got a failure to appear, they call it an FTA, and a warrant for your arrest. All is not lost. You can still contact the court, usually email them, and you can tell them and be very humble about it and apologize, explaining why it was just an oversight or an inadvertent error on your part that you missed this date. Generally, it is. People aren't bad. They usually just don't say, I'm going to throw this ticket in the trash and I'm not going to look at it.
Right.
But let's say once you talk to the court, and the court will usually give you a certain period of time to appear to explain why you missed the court date, and then they take the bond back. I don't want to say revoke the bond. They usually on a PR bond anyway. You wouldn't be on a bond unless it was a jail. Unless you're going to be in jail. But anyway, you are going to have a warrant out if you don't appear, and they will rescind the bond if you go and you talk to them and tell them why you missed the date, and they'll give you a new date. Now, if you miss the second one, they're going to put a warrant out again, and they may not come after you because they're busier with other bigger criminals and traffic people, but they may, next time you get stopped, see there's a warrant out, and you could be placed under arrest and taken to jail because there's a warrant out. It's not a warrantless arrest. Plus, they can search your car under there's certain ways that they can search your car, and one is incident to arrest. And if you're arrested because you have a warrant, they can search your car unless somebody picks you up. But that's a whole different program. Let's just go back to you got a ticket and you missed your date. The first thing you want to do is contact the court where the ticket is, regardless of what county it is. Explain, why you didn't make it, whether it be COVID or you forgot or whatever. These are people that work for the court. They understand it happens all the time. They will more than likely rescind the warrant, or they'll make a note that you've got a court date coming up, and you can show that. Keep it in your car, so if you get stopped, you can say, "I'm taking care of this." Okay. Now let's just say you have a bunch of tickets, or your kids have a bunch of tickets. They're just reckless drivers, and they got a new car, and they like speeding, or they like to antagonize the police, man around the corner, or whatever. Or let's just say that you got a bunch of tickets because our friend of yours, our client of yours, has a ticket for no driver's license, no insurance, no license plate on the front. Lots of people have that one because the European cars don't have a place for the license plate.
Right.
Any number of, you have a tail light out. I get the notices on those all the time. I never know when my lights are out because you're driving your car. You can't see it. And
Right.
so you got a whole list of these tickets. And let's say you missed all those dates, if they're on the same date. You can still ask to go to court and have them reset it so you don't have, a bond for all these failure to appears. These days, with the institution of the internet, almost every JP court has their records online, whether it be in Harris County, Waller, Montgomery County. You can actually go and search for your ticket and see, if there's a failure to appear, if you have a ticket that's outstanding, what your date is, and what the cost will be to rectify it. And you can settle it up just by paying it. And then you get rid of, the warrants will be, I don't know if you can get rid of a warrant that way, but it seems to me that if you contact the court and you settle up, the warrants will go away because you've already paid the punishment of it, right?
And so tell me, what would they do? Just Google Montgomery County District Court or Montgomery County JP Court?
Well, they'll know where they got a ticket, so this is not going to be a surprise to them that they were stopped at some point.
Yeah.
It used to be those red light, the camera light tickets. You'd get mailed to any address that was on the, that attached to the car, and those got a little bit confusing. But those are outlawed in Texas. So there's no longer red light cameras, and if you got a ticket for it or it's old, it doesn't. I don't believe it exists anymore. An attorney could probably get that dismissed for you. Unless it was during a period, then they were in effect. And I think you could still argue, even at this point, that there would be a due process violation because you didn't get a speedy trial. And you have a right to a trial even for a ticket, even though there's no incarceration behind it unless there's, extenuating circumstances. But what you would do is, if you didn't know, let's just say you didn't know what county you were in because you were also intoxicated but you didn't get a ticket for that for whatever reason, you can go, if you believe it was in Montgomery County, or let's say you didn't know what county, you can go to the JP courts in Harris, and there's about 25 of them. So you're going to have to look at each one individually with your name and your driver's license number to search for this. But you can go and you can look to see if you're in their system. There's not one big JP, Justice of the Peace Court library for tickets in Harris County. You've got to go to each individual court. And let's say if you were stopped by the city of Houston or the city of Magnolia or the city of, Montgomery or Conroe, then that's going to be in its own little area of a computer database, so to speak. So you're going to have to do some work. And if you don't have a warrant out, you're not going to find it. But more than likely, you know where you were stopped. And if you were stopped, say, in Montgomery County, and you weren't sure if you're in Magnolia or Conroe, but your ticket doesn't show up in either court, either you got lucky, which is unlikely, or you're in the wrong jurisdiction for finding it. And you just kind of want to poke around. Most people that get a ticket, they don't just throw the ticket out. They usually keep it. And they're getting notices in the mail or their emails these days showing that they need to show up for court, or they have a failure to appear, or whatever it may be. So when you look that up and you find it, you can also see, like in Harris County, if you don't show up, they tag on an additional offense of failure to appear, and then they start adding like a penalty to it. So you can see the amount of money that you owe for this one ticket just accruing. And I've handled so many of those cases where you've got a long list of, you've got a person that's got a bunch of tickets, and their fines will have escalated to, $5,000 or $6,000. It's just insane
Wow.
that they're that high. And they're like, "Oh, I'm sorry, Miss Tony, I didn't know I had a ticket." And I'm like, "Oh, right, yeah, I'm sure you didn't."
Yeah.
They just ignored it because they didn't have a driver's license and they never got insurance. And they're just lucky that the few times they got pulled over, they didn't get thrown in jail for having outstanding tickets and warrants too. But policemen, a lot of times they're getting the ticket done, but they're not out to be malicious. And certainly with COVID, they don't want people jamming their jails if they don't have to have them out there. This issue them another ticket. So the circumstances is going to depend a lot on that officer. And if you're nice, you might forego being arrested, which is always helpful with my clients who don't have driver's licenses because they can't get them because they don't have a social, because they're not here legally. And I don't know how they avoid tickets or jail time until some other higher charge is lowered upon them, and then they hire me. But for some reason, I get these clients that have a ton of tickets outstanding in many different jurisdictions, and that goes to the question is, what do you do when you've got tickets all over the place and you've got $6,000 in fines here and $1,000 here, or even $1,000 in one place? That's a lot of money to
sure
have
is.
to pay off, and they will give you a payment schedule, but it's not always necessary to pay that traffic ticket. And this comes up a lot with my clients, and I just had one call me about this over the holidays asking, "Hey, Miss Tony, can't you take care of my boyfriend's tickets like you did before?" And I'm like, I hate doing stuff. I mean, I should be serving God by serving others, but it gets monotonous when you're helping the same people over and over for the same repeat issues, and you're not getting any money for it, and they're not learning what you did so they can do it on their own. So I'm here today to help our listeners do this on their own. They don't have to wait for my passive aggressive wrath where I'm trying not to help them. I'm so desperately trying to get it to help themselves. What you can do is you can file what's called a motion for credit for time served with the court where the ticket resides, so to speak. So if you got a ticket in the city of Houston, not through a constable through the county, but through just a policeman, Houston City Police, because you, I don't know, you didn't parallel park right, or you were speeding through downtown. I mean, for whatever reason, the city of Houston was the agency that gave you the ticket. And let's say you forgot about that ticket, or you couldn't afford to pay it, or you were guilty as charged and just ignored it, because it used to be when you went to the city of Houston to handle a ticket, you were, in court for 5 hours because there was just so many people there, and you always waited to the last minute and you couldn't get a reset or get it paid for. And so, but they've made it so that you have this option of filing a motion for credit for time served. And this particular motion can be found, and I'm going to give you one location because it's kind of the same in all jurisdictions. You can go to the City of Houston website, and you can also go to our website, and the link will be there. But it's the City of Houston government courts, and it's under forms, and it's called a credit for time served motion. And what you do is it's a fill-in-the-blank form. It looks just like a motion that an attorney would fill out, except for you can just, like you can do in JP court with the petitions, you can actually just fill in the information. You're going to need to know you can't just give it to him and say, "I want my tickets dismissed." You go in and you fill in the cause number, which is your ticket number, and when it occurred and what it was for. And there's a lot of lines on this particular motion. I don't know if I can. I don't know where I don't know if I've got a camera on what I'm doing. I can kind of see it. I think I'll kind of hold it up here. You can kind of see what this form looks like. It's a little fill-in-the-blank one-pager. You can print it, or it's interactive. You can fill it out, or you can have an attorney fill it out. You may have more luck with an attorney filling it out, but it's not necessary. And an attorney may charge you, but maybe less than what the tickets are. But basically what you do is you fill in this form, and it says the state of Texas versus whoever the person that was that got the ticket, defendant's name, date of birth, driver's license if they have one, and then you list all the cause numbers, and right beside it you list what the violation was, and probably would be helpful to also put the date and the cause number is the ticket number. You fill this thing in, you read the acknowledgement of rights, and it's telling you that you're basically telling the court, I am guilty of this. And you're already guilty anyway, because you didn't pay the fine and too much time has passed, unless you can get them to continue it for you. But let's say you know you're guilty and you want to plead nolo contendere, which is the same as guilty anyway. And you just want to get it done and you want the fines. You want the warrants off, you want the fines off, you just want this done. You don't want $6,000 over your head.
Right.
You fill in the entry for the plea, and you complete. The only way you can use this, though, the motion for credit for time served, is if you actually serve time somewhere. So that's sort of what it makes it a little bit different. If you're not somebody that's ever been arrested, you don't make a habit of being arrested, although my clients do. If you don't have time served somewhere, then you can't use this motion. But let's say you got arrested because you got in a fight with your boyfriend, girlfriend, or you got arrested for a DWI, but you weren't DWI, but you didn't do the intoxilizer at the side of the road, and so they arrested you, pulled your driver's license. It ends up you weren't drunk at all. You just didn't want to do the sobriety test because you know that everybody fails it. And you did have one drink, and so there'd be alcohol in your breath. That's not against the law, but you didn't want to be arrested because you had alcohol in your breath, and it would show that. So you said no. You went to jail. These days in Harris County, and I think in Montgomery County too, they will put you before a magistrate and then give you a bond, but the bond amount is waived and you get a PR bond, and so you walk out for free. But you've spent a night in jail. All right.
Right.
That night in jail is basically sort of your get out of debt free card for tickets, because that one night can be used as your credit for time served, even if it was just a couple of hours. If you were deemed to be arrested, even if you didn't go to jail, but it's going to be kind of hard to prove you didn't go to jail unless you've got the arrest record. So what you do is you attach some record that you were in jail for that period, and the courts, if the judge grants this motion for credit for time served, they will waive that few hours or that hour of time served. They'll waive all those penalties and fines, and all those tickets are satisfied. Yes.
Wow, that's fantastic.
Yeah, you will have a guilty on your record, or nolo contendere, which is pretty much the same as guilty for the purposes of traffic tickets and for your insurance and for the DPS. But if you did it and you didn't have a license and you did all these things and you just want these age-old tickets to quit accumulating interest and you want them done with, then you can file this motion. And what you do is you do it all online. You don't even go before the judge. At least in the city of Houston, you can file this motion online to the judge's email address, and that's looked at by the people that work with her. It's usually, the judge was a girl. Every time I've done one of these, it's always been a female judge, but it could be a guy. And they will basically, without even having to do a notice of submission or anything, they'll just have it as a submitted, and then they'll let you know that it's been either granted or denied, and then all your tickets are paid for. And this is basically for my clients that call me and say, my boyfriend got arrested for whatever the reason is. Can you get him out? Can you get rid of all of his tickets? Or I got arrested for whatever the reason is, and can you do that thing for me again? That's what they always say. And I'm like, I'm always getting you motion for credit for time served. Do it yourself. And so I ask them, can't you just use what I gave you last time? No, I don't know where it's at. Well, now I'm going to say, go to the show.
Yeah.
Google my show, or Google this website. You're going to get the motion template, motion for credit for time served. And typically, the way there's a few little things you have to know. First, you can't use a motion for time served if when you served time was before you got the ticket. It doesn't work that way. You got to pay the penalty after you've done the bad deed, right?
Right.
And you. The way this particular motion reads, and you can use the same motion for different jurisdictions, but you have to cross out. This one's for the City of Houston Municipal Court. You'd have to put on the top, Montgomery County, JP Court, whatever. If you don't want to retype it, then you're going to have to cross through to make it applicable to the jurisdiction where the tickets are. And you can when you fill this in. Gosh, I lost my train of thought thinking about how you have to change that thing. You complete it and you file it, and where was I going with that? The caveat. It has to be in the same. Usually, when you're asking for a motion for credit for time served, the way it reads is it looks like you would have to have been in jail for an offense in that same jurisdiction. In other words, I'm trying to get City of Houston tickets dismissed with motion for, or not dismissed, the motion for credit so I don't have to pay the fines. I'm trying to get that done, so I need to also have done something, apple for apple. I've got to have done something in the City of Houston and have been in their jail. But that's not how it works. The City of Houston municipal courts will let you have done time in, say, Fort Bend or in Chambers County or in another county, if you can show them that you served time anywhere. After these tickets were issued, they will grant the motion for credit for time served, and you won't owe the fines anymore. And so consequently, there won't be warrants out for your arrest for not having paid these tickets, right?
Right.
You can apply the same language to ask for a motion for credit for time served in Montgomery County, to the county courts, you could probably apply it. I mean, I've applied it when I've had people arrested, which, by the way, I also got them exonerated. So they were arrested for felony cases in Montgomery County. But I didn't, it's where the ticket is. So you go to the court where the ticket stands, and that's usually a JP court, and you ask them to give you credit for time served for when you were arrested improperly for a felony or whatever the case whatever the case is that you were in jail for. And you don't even have to show the case, you have to show you're in jail. I mean, it could be that they took you in for public intoxication and didn't even charge you. Just show you were in jail, and then this will work for you. So that's the first thing. So to answer the first question, do you have to pay for the fines on a traffic ticket if you pled guilty or you've ignored it and you're deemed guilty and you didn't get with the court? No, not necessarily. If you've been in jail during or after the ticket when it was issued, but before you pay the ticket, then you can move to have the time served in place of payment by filing a motion for credit for time served where that ticket sits and being able to prove that you were actually in jail, even for a limited amount of time. And this is golden, because if your client or your friend, your family, or you or whatever has, thousands of dollars in tickets, if you're in jail for just a few hours, it waives them all. And
That's great.
And I want to just add that, let's say you've got a ton of tickets and you're feeling, downtrodden, and I can't get on my feet, I don't have a job, I've got all these fines. You can literally say, I want to go to jail instead of pay these fines. And you can go to jail for the afternoon, and I think that'll wipe all the fines out. I don't think they'll keep you in jail for very long at all. My clients have never stayed in more than overnight at the max, and I've had some that get released, within a few hours. They turn themselves in the afternoon and then release before the evening. So it just depends. A lot of things go into play about your attitude, who you're speaking with, how polite you are. Kindness goes a long way. Trying to do the right thing goes a long way. But this is an option for you not to have to pay that fine for traffic tickets. And again, you could fight them. You could try to get it reinstated and go to court. But even as an attorney, I can tell you that I went to court for a traffic ticket for my daughter and lost to a jury when
my goodness.
When I had every defense you could imagine. There was no way they could prove she was speeding. She had witnesses. She was on the feeder of 45 going north by where, I think where Michael's is. And she wasn't, they had no evidence. There wasn't any tracking or radar or anything. But the jury said, we believe the officer over your daughter. They just didn't care. It didn't matter. You're innocent until proven guilty in these traffic ticket courts, which are... a lot of times the judge is just a citizen that's been appointed. You don't even have to be an attorney. And then you get a group of people that come in. And a lot of times those jurors are not even qualified to be jurors because they've got, they're not citizens or they have got felonies or whatever. All that aside, you're just trying to get rid of the ticket. So if you're thinking about going to trial to get rid of the ticket, you might win, but it may be just a lot easier to, buckle up and say, you might be able to get a motion to suppress the evidence before trial, and the judge might think that's pretty clever if you actually can provide that evidence. And that kind of gives a segue into our next segment of how you may be able to suppress the information to get out of the ticket. But I will just say it's really hard to get out of a ticket. However, that being said, segment 2 is...
if you're stopped, the segment 2 is if you're stopped for traveling over the posted speed limit, are you guilty of speeding?
Right, and that goes toward if I go to trial, can I win? Even if it's a biased court with a bunch of citizens who've already believed that I'm guilty when I walk into that little JP court for my trial, and the judge is already aligned with the government because he's been appointed and he's paid a daily fee, and the officer and him are all buddies because they work out in and out of the same precinct or he wouldn't have been appointed. All these things are going against you. You're certainly not going to win at a bench trial under circumstances like that.
Right.
But so it's almost better to go in, which I've done in smaller communities, and tried to work something out and get it dismissed that way with the prosecutor rather than go all the way to trial. But if the question is, if you are stopped for traveling over the posted speed limit, are you guilty of speeding?
Right.
So this is just a pure black and white question of, this guy said I was speeding, I wasn't speeding, and even if there's some evidence that I was going 75 miles an hour in a 60, or like my daughter was, I was going 55 in a 45, because those feeders are 45 miles an hour over there off of 45 in front of the Woodlands, and those are speed traps deluxe.
They sure are.
They are at every corner waiting for you to come out of the bar, even if you only want to drink, they want to get you for a DWI, or they want to get you for speeding. It's just how they make their money over in Shenandoah, over there in Oak Ridge. You're just, you got to be going 45 and driving pretty well, or have some witnesses. I've gotten pulled over several times over there, and fortunately I never got a ticket, but it also helps because I knew to behave and be polite, and I was ready for a ticket. But being kind and nice and gracious with your police officer goes a long way. They don't know I'm an attorney, but it does. If you're nice, they'll just give you a warning and say, don't do it again. But if you're driving crazy, or if you have aggravated police officer, you're going to get a ticket over there. And but here is the code. Texas Transportation Code 545.352 provides that you must be traveling unreasonably and unprudently under the circumstances to be deemed to be speeding. Okay, and that's critical. I didn't even know that. I didn't even know that was an argument. I tried to fight my cases with radar and, not just radar, but all those different DARs. Some satellite or a gun or whatever, or there's no witnesses, or you didn't track me. You don't have to. That may not be your best argument. Your better argument may be this Texas Transportation Code 545.352, and there's a link to it, or there should be a link to it on our Facebook page if you go to it. But I'm going to read it. All right. Texas Transportation Code 545.351 it's called the maximum speed requirement. That's what the statute's titled. The subsections A and B1 are speeding statutes in Texas. Basically, they say you're speeding if you're driving at a rate of speed that is, quote, unreasonable and imprudent under the circumstances then existing. All right? And I'm going to actually quote the actual statutes here in a minute. But the second part of that, the statute that's just below it, if you were to go into Google and type in Texas Transportation Code Section 545.351, you would see 352. And that's and I never get this Latin word right, but maybe you know how to pronounce it, prima facie speed limits? What is
I say prima facie or prima facie. A lot of people say prima facie.
I don't know what our Texas Latin is, but if you were to phonically spell it out, it looks like prima facie. But I've heard it pronounced every different way imaginable. This statute, the 3.352, says that a posted speed limit is prima facie proof that you are guilty of speeding. That is, that the speed at which you are traveling is unreasonable and imprudent under the circumstances. But prima facie, that Latin word, means, quote, sufficient to establish a fact or case unless disproved, or at first sight before closer inspection. In other words, if upon closer inspection there is sufficient evidence that the speed at which you are traveling is not unreasonable and imprudent under the circumstances, then under Texas law, you are not speeding. And so an example is if you're driving 75 in a 60 mile per hour zone, and it's not a construction zone, and let's say you're on 105, and let's say you're on a part of it that says 60 miles per hour, because when you go on those country roads back and forth between A&M or wherever you're traveling, the speed limits will jump around quite a bit, particularly if you're going through a small town, because they're looking to make revenue for their speed trap. And also trying to, protect the public. But if it's 2 a.m, it's unlikely that people are going to the Sonic and they need their public protected. Or if you're going through your subdivision and there's a 20 mile per hour sign and you're coming home late and it's 1 a.m, and the speed limit has been reduced to 20 miles per hour going through the park, but you're going 40. Well, it's not deemed. I guess I believe that your argument would be. That upon closer inspection at that hour, there is no safety to the public because it's 2 a.m, there's nobody out, right?
Yeah,
And so that would be your argument. Now, it doesn't necessarily mean if you're going over the speed limit that you're speeding. If it is not unreasonable and imprudent under the circumstances then existing, then you could lawfully drive a higher speed. And think about the times, and I know you've done this, I've done this, we all have, that you've gone with the flow of traffic, even though everybody was going faster than the posted speed limit. That happens on the tollways all the time. You see those little, I don't know, are they like little, the Harris County sheriffs? I've never seen Montgomery County, but particularly going back and forth to Houston, you'll see these SUVs with they're either Ghost or they're Harris County, and it doesn't look like there's anybody in them.
Or there's a mannequin in them.
Yes, to make you slow down or to scare you or something.
Yeah.
But if those 18-wheelers next to you are going 80 miles an hour and you're going 80 miles an hour, then you're going with the flow of traffic because that tollway doesn't have any exits. Nobody's generally, there's no dogs or deer or anything passing through in those sort of remote areas. I've never been stopped on the tollway, but I guess it's feasible you could if you were going, so far over the limit. And one day, one of those little cars, those little decoy cars, may actually be real. Your argument would be, I was just going with the flow. The problem is although it's their burden of proof that you were speeding, it's going to be your burden of proof with the affirmative defense that it was reasonable. And so you'd have to have some evidence on like a camera on your car, that when right as you're being pulled over, people were whizzing by you, so they were going much faster, or there was somebody in the car with you that could testify to it, or better yet, someone was driving in another car beside you and sees you were pulled over and pulls over, and then maybe it was a friend or something. There was a case I was reading that went to the Texas Supreme Court. I want to say it was a fairly recent case where there was an argument that the person, this person was pulled over for speeding, and when they did I guess he agreed to let them search the car. That wasn't what happened because he couldn't let him agree. He didn't agree to let them search the car, but the police officer said he smelled pot, is what it was, and so he was arrested for he was stopped for speeding, but arrested for the smell of pot, and then within the car they found cocaine. All right, and the attorney asserted that the entire case should be basically dismissed. He filed a motion to suppress all evidence collected by that stop because his client wasn't speeding, because it was reasonable that he was going, I think it was like 80 and a 60 on that stretch of the highway. And it ends up that the appellate court found in favor. They reversed it. They said, yeah, we're going to throw everything out. There was no probable cause for the arrest because he had a witness that was driving. I don't know how he got her, but this lady testified. I was driving. I was on the stretch of road. Everybody was going 80 miles an hour. And then the appellate court said, yes, we agree. Oh, it wasn't the appellate court. I'm sorry. It was a motion for new trial. The judge said, I agree. I'm going to grant the motion for a new trial because it wasn't reasonable, but I'm going to suppress the evidence, which means basically they had to dismiss the case. They didn't have any evidence. If they had to suppress everything that came about because of that stop, right? It was an improper stop.
Right.
Ultimately, though, the Texas Supreme Court, I've got this right, I can't remember the Supreme Court, appellate court, but ultimately it got reversed again in favor of the state because they said that, let me see, they said that there was enough evidence of other driving infractions other than the speed, is what it was, that they could have stopped him for. So it would have worked, but for the other bad driving. That was also on the ticket. So that's how they lost on that one. But it goes toward if you're stopped for speeding, and that's the only thing that they said that they stopped you for, then if other bad things were going on and you didn't give the authority to search and they searched your car and found all other kind of things that it put you in a world of trouble, like what was in the car, credit card abuse, let's just say maybe it was in your car and it was somebody else, your kids or, relative or something or ex-spouse or something that had that in there and you were still not the one that they should have arrested, but for whatever the reason may be, you can actually get that information suppressed, and the case may be able to be dismissed based on the state not having evidence if speeding, significant speeding, is the reason that they're arguing. The only thing that they showed that they had to stop you, that was their probable cause for the stop. There was another case that was I was listening to a Zoom meeting, which we were just talking this afternoon. I love these Zoom meetings. You learn so much. This attorney was arguing that it was his they shouldn't be probable cause for the stop for his client for DWI because of this statute, this Texas Transportation Code 545.352, because it was reasonable that he was speeding. However, his argument really failed. I mean, it was a good try, but a lousy argument because this guy's client was speeding through West U about, if I got his facts straight, at 80 miles an hour at 2 in the morning, and it was a 30-mile-an-hour zone. It was something like, way over the speed limit. And
Right.
And it was going through West U. And his argument was, well, it's 2 in the morning, so there shouldn't have been a safety issue. The problem was nobody would have been going that fast through West U at any time of day, no matter what. You've got dogs, cats, residential. It just didn't. His argument didn't fly, and and so then he, the judge said, no, you lose this hearing. I'm gonna not deny your motion to suppress, and then he asked the judge if he would agree to give him a preview of what the judge would offer without an agreed recommendation because the prosecutors weren't offering anything. And so that's kind of, your attorney's, your attorney, if you hire one, has different ways that he can hopefully be able to get you the best deal possible. In this case, the guy was clearly intoxicated, but the only thing they had him on was speeding, and he tried to use this to be able to get suppression, and it didn't work. So use it if it's reasonable. It may work. It may work, particularly if it's just a traffic ticket and you don't want to have to deal with doing a motion for credit for time served and you don't have much money. Let's say you were speeding because your dog was sick and you're trying to get him quickly to the 24-hour vet. It would be reasonable to speed under those circumstances if you weren't injuring anybody else. And let's say you didn't have much money because you just spent $1,500 getting your dog taken care of. I think the judge would be sympathetic to that, and they may or not suppress it, but say that there wasn't probable cause for the speeding. So just kind of keep in your back pocket that the prima facie speed limits are not what's posted on the sign. If there's a minimum, you won't get a ticket for going the minimum if you're in a traffic jam. So the same thing should apply about the maximum. You shouldn't get the max. You should be able to go over the maximum if it's reasonable. Everybody else is speeding. You've got some proof of it, that kind of thing.
Yeah.
All right, so that was our second segment. I was unaware that you could use this Texas Transportation Code 545.352, and when you're dealing with judges who are just people too, and you argue your case to them on a motion to suppress, which doesn't go to the jury, it goes to the judge. You may be successful, whether it be a judge in JP court or a judge at a higher court, because it was the reason for the stop. Okay.
So the motion to suppress, you're asking the judge to suppress the ticket?
No, you're asking for the judge to suppress any evidence that was collected due to that stop. You have to have
Oh,
a
right.
constitutional reason, a reasonable suspicion, and a probable cause for an arrest and the stop. And if the stop was not constitutional, warrantless stop, but let's say there was a warrant out. Well, no, they can stop you, and then you're probably going to get that's not an argument for you. If you had no
Right.
warrants out and they couldn't read on your plate that there was a warrant that was attached to the person, if there was nothing that they could get you other than there was speeding, and the speeding is what caused the stop. That was what caused the smell of alcohol or whatever precipitated or was listed in the offense report. If you the only thing they had was the speeding, you should be able to get any evidence that was collected after that stop to be suppressed, and that would include all the officer statements. That would include the video of of you speeding if it was reasonable. It would that kind of goes back to a case that I had done maybe 10 years ago, and I know I may have told you about this case, but it was a really, really important case. I'd met my client in the holdover jail. I didn't want to represent him, but he I'm all about serving God by serving others, and I felt really bad for him because he was a felon because he had pled guilty to being a sex offender for having sex with his 15-year-old girlfriend when he had just turned 19 and she was getting turned 16. So she was like 3 years and 1 month outside of the range that you have as an affirmative defense for dating for statutory rape. And if you're 3 years or less older, then it's a boyfriend-girlfriend situation, and that's your affirmative defense. And so anyway, this guy pled guilty because her daddy was the district attorney for that small county, and so he was a registered sex offender. And so he was in a bad place because he had after that gotten another felony, and it was an assault. It was not the same girlfriend, but it was another sort of trumped up charge that he just buckled down and didn't try to defend himself. He didn't have any money. Where he had gotten in a fight, it was she had said that he tried to run her over with the car. She recanted. They didn't take it. He didn't have the money to fight it. He went ahead and he pled to a state jail felony. So he had 2 felonies now. So by the time this new case came up, he was working as a bouncer, or he used a different name for it, but basically he was working at a club in the warehouse area of Houston, and he went to go get ice. And he was just kind of handling this whole, shindig or wave or whatever it was, rave. And he went to go get ice and got pulled over because he had, I'm trying to think what they pulled him over for. I think they said maybe it was a warrant. No, he didn't have a warrant. They pulled him over because a headlight was out. That was what it was. It was something just dumb. And when they pulled him over, he had a lot of cocaine in his car, and it was not within sight. It was under the seat, but it wasn't his car. He had used his friend's car to get the ice. And he probably knew his friend had it in there, but regardless of why it was in there, he knew it was in there, but he needed that car to go get the ice for the rave. Okay. Yeah. And so he got pulled over, and when they pulled him over, he knew, he was savvy to the law. He said, "Why are you pulling me over?" "Well, because you had a headlight out." And he said, "Well," and then they learned when they pulled him over, they said he did have a warrant. It got a little bit juicier than that. There's a warrant. We're going to arrest you. And he said, "Well, hey, wait a minute. Can I call my friend to come get my car?" So he did. He called his girlfriend, who came to get the car, but the police searched the car anyway. All right. So when they searched the car, that's when they found, quite a bit of cocaine in little bitty packets, so that it would be sellable. So it made it not just for personal use, which is one charge, but now it's to distribute or sell or whatever. And I can't remember all the codes, but basically he was in a world of trouble. And so since there's a 3 strikes you're out rule, they had him kind of over a barrel. And I went ahead and I took his case. I didn't want to, but he just convinced me that his life was bad, and he needed help, and and I kind of listened to his story for about an hour, and I'm like, oh, I shouldn't believe these things, but I'm going to. So I took his case, and it ended up that he was really it tested for cocaine, but they shouldn't have searched his car because they searched his car incident to the arrest, but it seems like the warrant they had wasn't valid or something. There was some way I got around it so that the warrant wasn't there and they should not have searched his car. And so we went to a full-blown felony motion to suppress trial. And it was like a trial because I had to pick a jury before we even got to the motion to suppress because the prosecutors were just going to, they were salivating over winning this felony and getting this guy to have the 25 years because it was a 3 strikes you're out, third felony, or it may not have been that high because one was a state jail felony. But regardless, he was in a lot of trouble. And so we argued to the judge that, and I can't remember the Supreme Court case, but it was one out of Arizona again. They're all out of Arizona, I think. There was a case, and the case said that you can't, it was a motion to suppress case. You can't search a car unless the search is incident to the arrest. And because it was a headlight or a blinker or whatever, they wouldn't have searched his car for drugs. Okay, they couldn't even have gotten a search warrant for that. And so after arguing the Supreme Court case, which of course I cannot remember the name of right off, but if anybody wants to email in, I'll let you know because it was successful and very trying. The judge said, I was able to prove by going to the statutes of the constables in the city of Houston and the ordinances that it was their typical rule that if somebody could come get your car for you, that they didn't have to search your car incident to arrest because the purpose for the search was to inventory the car. And they didn't need to inventory it if somebody was available right then to drive the car off. So those motions to suppress are really, really important because I was able to get the search suppressed because of I don't think I got the ticket to go away, but I got the search to go away. I was able to get all the evidence to go away, and he was dismissed and didn't do 25 years because that was the minimum for 3 strikes out. So or 10 or whatever it was, because state jail felonies and the 3rd strike with that felony is a little bit different. But I'm just telling our listeners that if a stop is improper, you're not arguing with the officer. You're taking notes and making sure you can provide this to your attorney or that you can look it up yourself to know that you don't have to just settle in that I'm doomed. This kid relied upon me, and for some reason, through the grace of God, I believed him, and I was there, and I was able to get him out of a mess when he was feeling like my life I never get any breaks. I had a bad experience with my girlfriend, and then I got, I've been railroaded into these felonies, and I'm not a bad person, and I work, and I try really hard. Yes, he shouldn't have been doing a rave with cocaine in the car, but it wasn't his car, and he shouldn't have been driving that car, under those circumstances, but he wanted to get the ice, and he just seemed like a really nice guy to me, and this shouldn't have happened, and the judge saw it that way too, but it was just a matter of not ever giving up and just trying as hard as we could.
Right.
All right, so I'm not even sure how much time we have left over. Do you have any idea? I've got a clue.
We've been on for 54 minutes.
Okay, so we've got about 5 more minutes, I think. Would that be about right? Station Manager Dick is agreeing with that assessment. So the first question I have is, Christine, what out of everything that we've covered so far, what do you have to add, or what questions do you have, or what is your feedback on all this?
Well, I have a question for you.
Okay.
I had a client that got stopped. Listen, police pulled up to him. He was in a parking lot, and he had his headlights on, and it was at night. It was about 10:30, and they asked him to show proof of insurance.
Okay.
And he didn't have it. So they ended up arresting him, searching his car, and finding some drugs in his car. Now, would that is it just for speeding that you can attack?
Well, no.
This?
The first question is what crime was he committing wherever he was at? So you said it was 10:30 at night. He was in a parking lot with his headlights on. He was sleeping in his car, right?
He was, that's exactly right. And he wasn't in a parking space.
Okay.
He was sort of rolled up. I believe it was in front of a school.
Do you know, I've done that before, not with this husband, but with previous husbands. I've been so upset that I didn't want to pay for a hotel, but I didn't want to be at home.
Right.
And because things had escalated, and I'm a fight or flight kind of person. I will leave a situation before I let it escalate even worse than it is. And so I sleep in my car. And there are, I believe it's Walmart and maybe Home Depot. There's some places that allow you to almost as a sanctuary. And I know for sure Walmart, you can sleep in their parking lots in your car
Yeah.
without
Yeah.
because it's private property and they're allowing it. It's not a trespass for that, particularly because they're open 24 hours and it's kind of safe and they've got security.
Right.
I don't know if that's still the case or not, but the first thing that you're telling me I would look into is to find out if that particular parking lot was a safe haven or they'll say we're not going to, he could stay here if we wanted, we really don't care. I mean, we've got commercial property, Gemini. I could go sleep in my parking lot. It's my property. There's nothing to say I
Right.
can't. So I don't think the police asked him, is this your property or do you have stock in this company? And maybe that's an argument too. The first question would be, did they have a right to even approach him under those circumstances? Welfare check, maybe, maybe not. I think that if he was sleeping in his car, it wouldn't be a welfare check if he was breathing and he waved him off and said everything's fine. Did they say, maybe I didn't hear you right, did you say they smelt marijuana or alcohol or what did they say?
No, they, he.
Oh, no
they
insurance.
No insurance, right?
Why would he need insurance if he's in a stationary car and he's not driving? That doesn't make any sense.
Well, all that, that's the argument that attorneys make, but then, how they counter that is, well, we assume that he drove because he's here, his headlights are on, he had to drive
Well,
here.
that's their burden of proof to show that he was driving. He could have had someone else drive and then he jumped in. Maybe somebody went into Walmart or wherever the store was. So that's lame. I think that's a good motion to suppress case, whatever you said that he got arrested for not having a license. That's pretty terrible. He must have made the officer mad.
Well, what happened was he had just switched insurance companies. He didn't have proof of insurance.
But that's no big deal. You get a ticket for that.
And they searched his car.
And
they searched his car and they found drugs.
I think that's a good suppression case because if you can show that the place where the car was situated and he wasn't driving that's the first direction I would go. I would try to find out if they would have. If they have a rule, if it was a Walmart or a Home Depot or something, where you are, or a Kroger, where you could have that as a sanctuary if you needed to sleep off, alcohol, or if you needed to, separate from a spouse or your girlfriend or something, or for whatever reason your car broke down. I mean, his car could have broken down. So, I mean, that's also an argument, depending on what he told them. That's why you never want to say anything to police. I was sleeping here because I was waiting for a tow truck. I wasn't doing anything wrong. That's a legitimate argument, too. That's why you use your Fifth Amendment right and don't say anything. But I think that that's a pretty good suppression case from what you're telling me because nobody evidenced he was driving. You can't assume he was driving because he wasn't driving and he wasn't on a public place. I don't see that he's committed any crime, not an arrestable crime. And even if he did, they should have been knocking on his window. Yeah.
Well, what he told them, they asked him, if we search your car, is there anything we're going to find? And he told them, well, there's some marijuana in the center console. So then now they had cause to search his car. That's what they said.
He made an admission without being under arrest. That bothers me because even if they had no reason to ticket him, arrest him, he gave them a reason in the conversation. And at that point forward, he's made an admission. That's going to be more difficult. The marijuana laws have changed. They're not even arrestable offenses anymore. I think I might go direction with that. Okay, Dick has told me that I was supposed to wind up, I think, 3 minutes ago.
Okay.
So do you want to close this out?
Sure. Guys, we've been talking about traffic tickets and motions to suppress and fines and how to get credit for time served so your tickets will go away. Thanks for listening. We love you. Catch us every Tuesday from 12 to 1 on 104.5 and 106.1. And we want to remind you always to
serve God by serving others.
Have a great week.